Hear ye, hear ye. Now, Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh and give attention to the court is now sitting. God save the United States, the State of Michigan, and this honorable court. Good morning, and welcome to the final day of our April call. I understand we have members of the Explorers Home School Association here today. Would that be that group right there? No?
I think it's them over there.
Where
Raise your hands.
They're hiding. I guess that we don't. They aren't here today. All right. I was misinformed. Thank you so much.
Good job, Brian. You got him.
Perhaps they're not timely.
All right. Well, with that, let me make a few precatory remarks for those advocates who haven't been with us before or who have been here remotely. We provide the first few moments, whether it's a calendar case or an argument on application, time at the beginning without questioning. 5 minutes in the case of calendar cases and 2 in the case of arguments on the application. We give that to you question-free because we like to ask a lot of questions. I assure you that we have read your briefs, so there really is no reason, except as in developing your argument, that you go over background facts with us, and it's really an opportunity for you to lay out the outcome determinative issues that you think should compel the court to decide in your favor. So with that, I will call the first case, which is People versus Allen.
Mr. Chief Justice, Your Honors, and may it please the Court, Assistant Attorney General Linus Banghart-Lynn, on behalf of the people of the State of Michigan, the Ionia County Prosecuting Attorney, and respectfully requesting that this Court reverse the decision of the Court of Appeals. I intend to manage my time in such a way as to reserve at least 5 minutes for rebuttal.
And as manage your own time.
Yes.
Good luck with that, by the way.
Thank you. I'll try. As far as the question-free time, I don't intend to use all of it. I'll get to the crux of the issue, and then I'll open myself up to the Court's questions. The crux of the case here boils down to the plain language of 769.10, and specifically 101A, which provides that a habitual second penalty can be gives the trial court the discretion to enhance the penalty to 1.5 times the penalty that would be prescribed for a first conviction of that offense. So the key words there are of that offense. And then the question is, what is that offense? The error that the Court of Appeals made is saying that that offense here is any violation of SORA, and specifically SORA first. But the legislature has created different offenses under SORA, and the offense that Mr. Allen was convicted of here was SORA second. And so the penalty prescribed for a first conviction of SORA second is 7 years. So the trial court had the discretion and properly exercised the discretion to impose a maximum sentence of 10.5 years. The Court of Appeals erred and should be reversed. And I'd be glad to take the Court's questions at this time.
Why should we reach the conclusion that the legislature, the language they chose, first conviction of that offense, they meant first conviction of SORA second offense? Isn't that a little bit of a strange formulation?
I think that just on
how many convictions of SORA second offense can one have?
One could properly only one, because the second one would be properly under SORA third, although a defendant could certainly be charged.
Doesn't that read out that language, first conviction?
No, not at all, because this is his first conviction, but because he's a habitual, you enhance what would be the penalty for a first conviction. So it's not that the first conviction is different from what happened here. The first conviction is what happened here. This was his first conviction of SORA second, but because he had 2 prior felony, it could have been a habitual third.
But if he could never have a second conviction of SORA second, the legislature wouldn't have needed to talk in terms of a first conviction, wouldn't they? They just would say, for a conviction of that offense.
Well, except for when writing 76910, it was writing it for all the felonies in general except for the controlled substance offense. So there are plenty of felonies that you can get multiple convictions of.
I
For example,
agree, there are a lot of them where this is a better fit. The question is
Right.
it close enough to fit here?
It is, and the point is that there are some felonies that you could properly be convicted of only once, and some that you could be convicted of multiple times. And in fact, in reality, you could be convicted of SORA second multiple times because you could plead to it, right? And so even though you technically are a SORA third, you could plead down to a SORA second or a SORA first. So in reality, you could have multiple convictions. The point for a first conviction of that offense is simply setting the baseline for what the number is that is enhanced. And so when writing 76910, the legislature didn't need to say first conviction of that offense if it's possible to have multiple convictions, or a conviction of that offense if it's only possible to have one conviction. It's writing a general enhancement statute for all of the felonies. But I think the important...
It sort of begs the question that we're here to decide, which is whether it should also apply in situations where the legislature has put forward a scheme where the second offense carries a higher penalty and the third offense and so forth.
Absolutely.
Like it does here, right? That's the whole question we're here to confront. I agree with you.
Yes, I agree.
Habitual statutes work very well in all those other contexts where it applies, where the legislature hasn't thought separately about enhancing the penalty for second and third violations. The question is, did the legislature really intend to have a double enhancement? And is that a sensible sentencing scheme?
Yes, Your Honor.
Why?
And the reason is because the legislature, instead of doing what it did in the Controlled Substance Act, which is where it created one offense for each sort of actus or intended circumstance and then created a separate statute that enhanced the penalty without creating separate offenses. What it did here is the same thing that it did in retail fraud, fleeing and eluding, OWIL, which is to create separate offense for recidivist violations. And we know they're separate offenses for a number of reasons. One reason we know is because when we look at MCL 777.11b, which is one of the sections in which the legislature enumerates all of the felonies it has, in order to tell the courts what class and category they're in. SORA doesn't occupy one space on that. It occupies 6 spaces, right? So 1A, 1B, 1C, 2, 3, and 4 are all on there as separate felonies. 1A, it could have said 1 is 1, 2, 3, and 4, in which case we'd know 1A, 1B, and 1C are all the same offense. But instead, it listed it 3 times. And even bolstering that, it gave them separate classes, which it wouldn't do if they were all the same felony. One felony should have one class. This has different classes for different. 1A has a different class from 1B.
Might it be the case that it's the same offense, but if it's you're a multiple offender situation, the legislature simply thought you should be in a different crime class? Why does that lead ineluctably to the conclusion that it's a different offense?
I think it leads to the conclusion that it's a different offense because the legislature listed it 3 times in that list. It would have listed it, if you go to the controlled substances felonies that are in the same list, not in 11B but in another part of 777, it doesn't list this particular violation first offense, this particular violation second offense, this particular violation third offense.
Let me ask the question this way, because what really sort of gets me on cases like this as a former trial judge is, we talk a lot up here about whether defendants and people and ordinary citizens could read the laws and understand what the law prohibits and what the penalty is if they violate the law. And here we have a law that it's pretty clear what it prohibits, but if you want to know the penalty, I have to dance around from the very provision itself, which has a penalty provision, to the habitual sentence or statute, which doesn't really fit that well, but may fit. And then I have to dance all the way to the sentence guideline scheme to try to figure out what the sentence is, rather than just reading the language of the offense that the legislature wrote that seems to apply pretty closely. It says, for a second offense, this is the penalty.
The problem with that is that the reading that the Court of Appeals gave it is more confusing than what we're proposing because it creates a conflict. The misreading that the Court of Appeals gave it, and in fact the Court of Appeals thought that the statutes conflicted because of this misreading. So if I want to know what my penalty is for a second SORA offense, I could say, well, it's 1.5 times a first, so that's 6 years. But then I also look at SORA second, and it says 7 years. So is it 7 years or is it 6 years? That appears to be a conflict, and the Court of Appeals said that it was. But instead we say, No, it's 7 years, and the trial court has the discretion, if it habitualizes you, to make it 10.5 or 14 or life, depending on the level of the habitualization. So there's no conflict there. It's 7 years as your baseline, and then it can be habitualized from there.
But the question put to you was, how can a person know that what the potential penalty is if they have to look beyond what SORA 2 provides?
To put a finer point on it, how would they know when they read a statute that says if you commit this offense for the second time, this is the penalty, that the legislature didn't really mean that? What they meant is, this could be the penalty, but you have to look elsewhere.
Actually, it's never the penalty. It's never the penalty.
Yeah.
What the statute says, that, SORA second is 7 years and SORA third is 10 years, is never, ever going to be true, right? Because you're always going to be a habitual.
No.
So really, it's worse. The average citizen reads the statute, which seems to be like a sweeping, comprehensive view on how the law treats sex offenders. It reads that way. It's a pretty comprehensive statute, and thinks that what the legislature says in the statute is the penalty, but in fact it's explicitly never the penalty.
Isn't that true for any crime that can be habitualized? I mean, you have to look elsewhere than the actual
This is the part where the chief answers our questions.
I'm asking the question.
Yes, any time a crime can be habitualized, the defendant needs to look outside of that criminal statute to the habitualization statute. But I really need to get back to Justice McCormick. What you've said is that it's never 7 years, and that's not correct. It absolutely can be 7 years because the prosecutor can decide not to habitualize, and the trial court can decide not to habitualize, even if the prosecutor decides to. And so what the legislature has done is it has decided it wants to give the prosecutor a certain amount of discretion and the trial court a certain amount of discretion. The Court of Appeals reading strips that discretion away from those actors. And so it is not never 7 years.
But I guess, doesn't the habitual statute create the indeterminacy? In the sense of, if we're trying to figure out what the penalty is, it's the Habitual Offender Act that requires you to look elsewhere to see if you're potentially subject to additional penalties.
Right. I think that the natural reading is, if I'm being charged with SORA second, I go to the Habitual Offender Act and I say, oh, it can be 1.5 times. SORA second is 7 years. I go to the Habitual Offender Act, it says 1.5 times. That puts me on notice on 10.5 years. The Court of Appeals reading would require me to then go back to SORA first and say, okay, well, normally it's 7 years. Now it says 1.5 times, but it's going to be a different statute, different subsection of the statute that I look at. Now I look at 1A instead, and I see that it could be 6 years. Well, I really hope they habitualize me, because now I can go from 7 years to 6 years. Well, the Court of Appeals says, no, then we ignore the habitual statute. Now, the defendant might think, hey, the habitual statute looks great for me here, because now I'm going from 7 to 6 years. The Court of Appeals says, no, surprise, it's 7 years. It's a very confused reading, and I think that's why it's inconsistent with all of the precedent. It's inconsistent with this Court's precedent in Buersdorf. It's inconsistent with published Court of Appeals precedent, which is all cited in our brief, Ilola, Lynch, Brown, and
What should a trial judge be thinking of when he or she is exercising her discretion to decide whether to use the same underlying conviction both to raise someone from a SORA first offense to a SORA second offense, and also to habitualize somebody and have that added enhancement? What should the judge be thinking about in exercising their discretion?
Well, I think that part of the question assumes that the judge has the discretion to do both, and I think it's important to note that the legislature didn't intend to give the judge the discretion to go from a SORA first to a SORA second. If that's proved by the prosecutor, that's the crime, and I don't think that the trial court has the discretion to then say, well, you've proven SORA second, but we're going to convict you of SORA first.
All right, so answer the narrower question. To
Sure.
still use the same offense that was used by the prosecutor in achieving the SORA second offense, to now further enhance the sentence under the habitual statute, what should the judge be thinking about in a given case, aside from other sentence guideline factors and all the things that we ask judges to think about?
That's exactly it. That's exactly it. I don't think there's anything aside from that. The point is that you look at this defendant, just as the judge picks a sentence from the guidelines range or from outside the guideline, picks a minimum sentence from a range available to the judge. So when there's a habitual case, the judge can decide, looking at this defendant, looking at the defendant's circumstances and the circumstances of the offense, do I think 7 years is an appropriate penalty here, or do I think 10.5 years is an appropriate penalty here as a maximum penalty, right, the maximum date? And so all of the considerations in terms of the...
When would it be an abuse of discretion for the judge to do that, to give the added penalty?
The only thing to add the added penalty or to refuse to?
Well, either way, I guess.
Either way. I think the only way is if the judge were maybe operating under a mistake of law. I think it's necessarily an abuse of discretion to say...
So the trial judge has absolute power to set the maximum penalty?
I mean, proportionality is still the rule under Milborn, so I think if the judge were to impose a sentence that a reviewing court would be defined disproportionate, I think that would happen sometime between never and almost never, but in theory, the judge could abuse their discretion by imposing a disproportionate sentence.
But of course, the concerns that Justice Viviano is raising are just the concerns that are inherent in a system in which we give judges broad discretion to sentence, which is kind of our new sentencing world post-Lockridge. So it's an across-the-board problem, not just a problem here. Is that right?
If it's a problem, it's an across-the-board problem, yes. And I don't think it is a problem. I think that's what the legislature...
Of our creation. Or the U.S. Supreme Court's creation.
Or the U.S. Supreme Court's creation. But even under mandatory guidelines, the judge has discretion to go from anywhere from the bottom to the top, and that's virtually unreviewable. I wouldn't say it's entirely unreviewable, but it's really more reviewable in theory than in practice. And so, no, I think that either isn't a problem, or if it is a problem, it's a problem with sentencing as a whole and not an issue in this case.
Counsel,
yes.
If the legislature had genuinely intended to create separate offenses for multiple violations of SORA as opposed to creating one offense with aggravated punishments, why would it have done so in what seems to me to be the relatively odd fashion it's done here by having in Section 1 the definition of the offense, then in separate sections defining the separate punishments depending upon how many of those offenses you've committed? Doesn't that seem like kind of an odd way of achieving what you think this achieved? Wouldn't it have been better to have combined the definition of the offense with the punishments if what you're suggesting was the legislature's intention was genuinely what it was seeking?
I don't think so, Justice Markman. And what I would draw this Court's attention to is the meth manufacturer statute, which is at 333.7401C. And it did the same thing, but now that's not a recidivist provision. Under subsection 2, it says if you make meth, if you violate this act, you are guilty of a felony, punishable as follows. And then it has A, B, C, D, E, F. A is if you don't have any other attendant circumstance, that's your penalty. And then each of B, C, D, E, and F provides, well, if there's a particular attendant circumstance, if you do it in the presence of a minor, here's your penalty. If you do it involving the possession, placement, or use of a firearm, here's your penalty, et cetera. And so I think that the Court used this, or the legislature used the same language to introduce that subsection. And I think it's absolutely clear that the legislature intended to create 6 different felonies, 6 different offenses. And in fact, this Court in People v. Routley said those are different offenses.
I mean, you may in the end be right, but I'm just saying it does seem to me a little bit odd that where you have A, B, and C that are distinguished only in terms of the punishment, that a court of law might think the alternative approach was what was genuinely intended by the legislature here.
I understand, but I think that if you were to read it that way, that would, I mean, they used the exact same language to introduce that meth manufacturer statute, and I don't think there's any argument that they intended to create one offense there. It's 6 separate offenses. This Court has held so, the Court of Appeals has held so. They are separate offenses, and so too here. I agree the language, they could have done it more clearly, they could have done it differently, but it is clear enough that what they did here is to create separate offenses. And not to preclude enhancement under the Habitual Offender Act. What's more, the legislature knows how to preclude, right? They have amended the retail fraud statute to say you can't elevate this using the habitual offender statute. They wouldn't need to. That would be a nullity if the legislature intended that as a general matter, these should never be enhanced using habitual offender. Retail fraud, again, it's a recidivist provision exactly like we have here. I think this court should follow Buersdorf, which nobody has offered a reason to distinguish it, and my opponent has not asked that it be overruled. And I think this court should follow the plain language of the statutes, and I think this court should reverse the erroneous decision of the Court of Appeals. I'd be glad to answer any other questions, but otherwise I'll reserve time for rebuttal.
Thank you.
Thank you, Your Honor.
May it please the court, my name is John Ulacki. I represent Floyd Allen, the defendant appellee. This case is all about statutory interpretation. What did the legislature intend? If this court finds that it did intend to double a penalty that already had, or increase a penalty that already had a built-in increase in the criminal act, then you'll find for the appellant. If you believe that the Court of Appeals was correct by saying that if you do have statutes that conflict, can they be harmonized in such a way as to give effect to both? And that's what they ruled, saying that the SORA second offense has a built-in enhancement and is more specific than the general habitual second. Does the court have questions?
Yeah. Why? Why do you contend it's one? If it's a separate crime, the rules provide. Well, let me just ask you. Tell me what the rule is. What is the principle upon which we should permit the habitual act to modify a penalty in the substantive crime, and when shouldn't we?
Well, to start
the principle we should be applying.
To start with, had the prosecution in this case used some other felony,
That's your quibble, right? You don't actually think the Court of Appeals was, I think, tell me, you think the Court of Appeals was also wrong insofar as it said that a sentence can never be enhanced by the habitual offender provisions. You just think you can't double count. You can't use the same one. Is that right?
exactly correct.
So you kind of agree with the prosecution that the Court of Appeals
If they would have
here.
prosecuted with any other underlying criminal act,
And
they could have enhanced the SORA second.
I get that argument at sort of a gut level. What's the legal authority for it?
How do we get there? That's why I asked what principles should we being applied here to determine when it's appropriate to use the enhancement of the multiple offender,
Double count.
Double
Let's call it
count.
double
That's why I'm not making the big money, because it's this court's interpretation
First line of the call. Yeah.
of what the legislature intended
Would you want to inform us how we should do that?
by telling the trial courts that if there is an underlying felony conviction that has an enhanced penalty, you cannot use it as an habitual standing alone.
But that's the
But
quibble
why?
here, isn't it? The quibble here is whether the SORA is an enhancement, the ratcheting up from 1 to 3 is an enhancement, or they're separate crimes.
It's definitely enhancement,
Why? How do I know that?
because the legislature said so when it said that if you're convicted of a SORA second instead of a SORA first, the penalty is going to be increased.
But why shouldn't I just see that as a separate crime? SORA second is a different crime than SORA first.
Yes, because it's the second offense. But the problem is that you can't use that first one as the basis for enhancing the second one.
We know that's what you're telling us.
But
We
why?
just want to know what the authority is for why you can't. We allow double counting in the sentencing context all the time. The OVs do. We permit double counting across the board. So why here is there something special about this statute that says?
I think it is, because you've got the Federley case that explained that, where you do have conflicting statutes rely on the one that is specific. And the specific penalty in this case related to the SORA first being used to charge the SORA second, which had its own penalty.
People versus Beersdorf, would we have to modify that, cabinet, reverse it? Is it applicable to your case? How do you get around that?
Brewersdorf was a 1993 case, and Federley came down in 1998 and explained away the difference as to why Brewersdorf wouldn't apply in Federley, and I think the principle is the same here.
Well, the principle stated in Federley, isn't it? I think, yeah, is that where the legislative scheme pertaining to the underlying offense elevates the offense rather than enhances punishment on the basis of prior convictions, both the elevation of the offense and the enhancement of the penalty under the habitual offender provision is permitted. It seems to me we are at the point of, if you agree that that is the principle we apply in determining.
I do.
Okay. So it looks to me like we're trying to figure out whether the SORA is merely an elevation or an enhancement of the punishment. And I guess I'd invite you to address why you think it's an enhancement rather than an elevation. Because you lose if it's an elevation. An elevation, right?
Yes.
The federally principle.
Yes, and the problem is that, again, I go back to the situation of the SORA first having been used as the enhancement statute.
You're begging, I think, the question I'm asking you is, I need you to explain to me why stepping up from SORA 1 to SORA 2 is not an elevation but an enhancement.
Because the penalty is greater in the end.
But always.
That sounds like an enhancement. Yeah.
Well, isn't that when the legislature absolutely intends to be an increased penalty for any subsequent case or violation, that's always an enhancement, in your view? It cannot be a separate, the legislature cannot create separate crimes that stack in terms of punishment.
That's what the prosecutor could have done in this case.
This is a question of what the legislature intends. That's what I'm trying to understand. When do I know that the legislature intends there to be an elevation as opposed to an enhancement?
That's the question the court's presented with today.
And you're not going to answer it for us, are you?
It's true, he's right.
Not any better.
We have to figure it out.
This is the dead mouse theory of advocacy. You brought us the dead mouse and you want us to fix it.
No, he didn't.
I didn't
he didn't
bring
want
it.
to come here at all.
Yeah, okay, right, all right, good.
Let me ask you a question. Is one way we could sort of figure out whether this is an enhancement versus an elevation that we know from other statutory schemes that the legislature knows how to say in the statute, don't use the habitual statute, and it didn't do that here, right? In other...
I'm not sure that they were thinking of that at the time it was passed.
Well, I don't know what they were thinking. We never know that. We just have to, all we have to do is look at what they gave us and then do the best with it. I mean, and we know in other statutory schemes, they know how to say, for this statutory scheme, don't use the habitual enhancement. And they didn't say that here. Is that meaningful to you, or should it be to us?
Not particularly. It's a factor, but is it meaningful?
Not
I don't really think so.
Okay.
Is there anything else meaningful you want to share with us?
No, Your Honor.
Thank you very much, then.
See you at the bench bar conference.
What are the three most significant factors that you think should lead us to conclude that this is an elevation and not an enhancement, the SORA statute?
I think the first is that the legislature has listed them as separate offenses when it's made a list of offenses, and it's given them different felony classes, which it wouldn't do if it were a single offense like in the drug code. Second, Buersdorf is so held. Nobody's arguing with Buersdorf. Federally, in dicta, Ilola, Lynch, Brown, all have so held. Nobody's quibbling with those. And I think third is that the legislature knows how to say, don't enhance here and here. It did it in the retail fraud statute, which has similar wording to what we have here, and it hasn't done it in this statute, which that would be a nullity in the retail fraud statute if it were generally forbidden. It's generally permitted because the plain language allows it, and the legislature specifically acted to say, don't do it in this particular statute. So those, I think, would be my 3 points, 3 key points. I also want to quibble a little bit with what my brother said. He said that the Court of Appeals here acted to sort of harmonize these statutes. The Court of Appeals did exactly the opposite. It found these statutes to be in conflict, irreconcilable conflict, and therefore it ignored one statute so that it could apply the other one, which is appropriate when statutes really are in conflict. But if there were any interpretation allowed here, and our position is there's not, the language is clear, but if there were interpretation allowed here, the principle would be interpret them as to harmonize them, which is what our argument does. As far as using the same conviction versus a different conviction, Justice McCormick, you're absolutely right. That happens all the time. The legislature knows how to prevent it when it wants to. PRV 5 is a good example. MCL 777.552 says if you've used a particular conviction to enhance one way, don't use it in PRV 5. But in general, OV 13, PRVs, habitual offenses, and recidivist offenses, you can use the same. The plain language allows it. No language here forbids it, and so there's no problem with it.
How do we know when the legislature intends to elevate an offense? What should we be looking for? For example, is it an elevated offense if the legislature creates degrees? Would that be a way of discerning an elevation in offenses?
Absolutely. I think I'd have an even stronger argument standing here if
Would it
these
be
have
an
been
elevation in offenses if the legislature changed it from a misdemeanor to a felony?
Yes.
Would that be an elevation?
That would be an elevation as well. That would be a different offense.
And here we just have an increase in penalties, right? Do you have anything else that I should be looking for to determine that this is, in other words, it's still a felony, but now we've just increased the amount of time the person can spend in the prison, and maybe the amount of the fine?
Yes, that's what the legislature has done. But, I mean, that's true.
Is there anything else that tells me this is an elevation, other than the increase in penalty? Because my follow-up question is, how do I know, how do I split the hair between the elevation in penalty in this genre, which only goes to an increased penalty, and the enhancement, which I think is also only defined by an increase in the penalty? How do I tell the difference between the two?
The point is that you've got an added fact that is part of the crime, right? And so it's like the difference between unarmed robbery and armed robbery. The only difference is the penalty, right? But you have to prove an extra fact for armed robbery, right? And so it's the same here, SORA first versus SORA second. The only difference is the penalty, but you have to prove an extra fact.
You have to actually put the conviction in front of the jury?
The Constitution doesn't require it, but I believe that's correct. I'm not sure if that's actually something that I'm not sure about, but I believe Buersdorf says it has to be proven by the prosecution. It didn't say it had to be proven to the jury, and I know that under Apprendi, of course, prior convictions don't have to be proven to the jury, but I think it does have to be proven to the trier of fact.
But that's because they're just used to enhance the sentence, right?
Because it's used to enhance the sentence.
If it were just an enhancement, you wouldn't have to prove it, right?
Well, but that's true of any element of any crime. I mean, the only thing that's different is here the element is a prior conviction, but that's also true.
Is it an element of the crime or not?
I believe that it is.
Who decides after Apprendi what the elements of a crime are?
I guess it just depends on what is meant by an element. If you define element as...
If it has to be proven, that's what an element is.
It does have to be proven. It doesn't have to be proven to the jury constitutionally, but it does have to be proven.
Well, wait a minute. Okay.
You might want to cite at this point Almendarez-Torres.
Almendarez-Torres absolutely says, and Apprendi, they both say prior convictions don't have to be proven to the jury. I would cite, and it's not controlling, but I would cite Justice Thomas's persuasive concurrence in Apprendi, because the Apprendi majority didn't say whether a prior conviction was an element. It did say it didn't have to be proven to a jury, but it sort of left that question aside. And Justice Thomas wrote a very thorough and persuasive concurrence saying it is an element, even though he agreed it doesn't have to be proven to a jury. The question, element is just a word. It doesn't really matter. The point is it's an extra fact that has to be proven. That's the point, and that is true here, and it makes it a separate offense. No less than the element of being armed elevates unarmed robbery to armed robbery, making it a separate offense.
Let's go back to the beginning point of this little frolic that we're on. How will our fellow citizens know the difference in this context between an enhancement and an elevation of a crime when they're reading the statute. Because it's not degreed offenses, and it's not even misdemeanor felony like in the OUIL context. You know, I guess as I'm sitting here, it's interesting. I think back, anything that I had to work really hard to figure out when I was a trial judge, I wonder how everyone else out there is going to figure it out. You know, I had to go from law book to law book and statute to statute to understand what the penalty was and how it applied in a given case.
Right.
And so now we're down to the nub of the issue. It's either an enhancement or an elevation. That sounds to me like hair splitting, like it's a construct that lawyers make up to try to define
I
a certain
understand.
outcome.
But I think part of our presumption, and it may be a counterfactual presumption, but it is a presumption we have, our presumption that citizens know the law. And I think in reality, when deciding whether to commit a crime.
They know the law because, you know, the work we do is to make sure that the law means what it says.
Exactly.
According to its plain language, and that clearly is not the case here. Right?
Well,
It doesn't
I think,
mean what it says in the SORA statute, that everyone would think if I commit a second offense, now I know what the penalty is. Everywhere else where there's a habitualization, it's not if I commit a second offense of this very crime, it's if I commit this crime, I also know that there's other provisions out there if I'm a multiple felony offender.
I think part of our presumption that citizens know the law, whether it's a true or counterfactual presumption, is that they read the common law as well. And so if we presume that a citizen has read Buersdorf and Alola and Lynch and Brown, then the
Is
citizen
that common
knows.
law, or is that a way to
Well,
help us interpret?
I
plain
guess I
language
should
of
say
statutes?
case law is what I meant to say, is that they understand, and again, is it true or not? It's a presumption that we have, right? The presumption is you're aware of.
I guess my point is, if your presumption goes so far as to assume that they had to actually go to law school to figure out all this, isn't that a problem?
No, I don't think so, because you don't have to go to law school to read Buersdorf, and there's no distinction.
Or maybe what you mean is it doesn't help that much.
I don't know if I have anything to add. No, I think that the law includes the decisions of this court and the published decisions.
Well,
of the
clearly
court.
it does. I'm just trying to figure out how somebody reads this statute and figures out what the penalty is without taking about 7 more steps.
Well, I understand, but I mean, that part of that is any habitualization statute. If you just look at any.
I would politely disagree. That requires 1 more step.
Sure.
And it's pretty clear, and the public is pretty well on notice that if you're a multiple felony offender, that you might get into more trouble. That's
Sure.
not a big shock.
Mm-hmm. I understand.
Counsel, is it fair to say that what you rely upon as the principal textual clues in support of your position are really not derived in any way from the SORA statute, but are in fact the negative implications that are derived from some of the exclusions in the habitual offender statute?
No, I wouldn't say that's the principal textual clue. I'd say that is one of the principal ones, but not the main one, no. But yes, that is.
I didn't mean
one.
exclusive, but they seem to be given some considerable emphasis.
Yes, I think I think so. I don't think it's, if that were all I had to go on, I concede that I'd have a tougher road here. I would still make that argument, but I think every clue here, I think, points in the same, almost every clue here points in the same direction, statutorily and in terms of the case law as well.
Thank you very much.
Thank you.
The case is submitted.